Okay, so we'll continue to admit people as folks join, but I do want to get started on time so that we have time to hear from our panelists and do some Q&A with the audience as well. So good afternoon, everyone. My name is Kelly Fong. I am an assistant professor of sociology at Georgia Tech, and I'm really thrilled to be with you all today for this afternoon's panel. We had such an invigorating symposium thus far, and I know that this panel will be no exception. So I want to thank the symposium organizers and support staff, as well as the Columbia Journal of Race and the Law editors for all that they have done to make this event run so smoothly. And I want to apologize in advance. As you maybe can tell, I'm getting over a cold or cough, so I promise my voice doesn't normally sound like this, but I wasn't going to miss this. So I will try not to talk too much. But I think that's great because we're here to hear from our fantastic panelists anyway. So as we know, family policing goes way beyond what's called the child welfare or the family policing system. It involves many, many other systems as well. And foster care is really just the tip of the iceberg. And so this session will reflect on this much broader reach of family surveillance. I'm thrilled to have a great set of panelists who can speak to various aspects of this surveillance. So just to provide a brief overview of the session today, we have until about 4. We'll spend the first 35 to 40 minutes or so hearing from our panelists. I will not present detailed biographies of all of their accomplishments, but those bios are available on the conference website. And I do encourage you to check those out when you have time. I will then ask a few questions to kick off the conversation, and then we'll take questions from the audience. And I really do hope to have a substantial block of time at the end to engage with audience questions. So please do submit questions throughout the panel using the chat function. And you can direct those questions to me, Kelly Fong, and let me know if your question is for a specific presenter as well. We'll get to as many as possible. If you want your question to be asked anonymously, please just indicate that in your message, and I won't read your name when reading your question. At 4 o'clock, our formal session will end, and there will be an opportunity for breakout rooms with some of our presenters. You'll have the opportunity to select a breakout room during that 15-minute coffee break before the next session. I'm looking forward to the upcoming panel. We're going to start with a presentation from Khadija Abdurrahman from We Be Imagining. Unfortunately, Khadija was unable to join our session live today, so she has pre-recorded a video of her presentation. So we'll play that video. I've heard that the audio may be a little bit faint, so you may want to turn up the audio on your system or make sure to turn on closed captions so that you can see what Khadija is saying. So we'll turn it over to Khadija's presentation.
Hey, what's good, y'all? I'm sorry that I couldn't be there in person, but I'm grateful to have the opportunity to present some of my research with you through this pre-recorded talk. My name is J. Khadija Abdurrahman. I'm the director of We Be Imagining at Columbia University's Insight Center in the American Assembly. That's a public interest technology project, and additionally, I'm an independent researcher looking at predictive analytics in the child welfare system. I have only 3 brief points that I'd like to make. The first is that the model and counter of the criminal justice system is a disposition other than arrest. In plain language, this means if we only look at who's getting locked up, we'll underestimate the breadth and impact of the police. Similarly, only about 4% of the children investigated by the New York City ACS in 2019 were removed. This is not to minimize the just less than 8,000 children in quote unquote care. It's to say that being curious about the full expanse of the family regulation system that includes, but is not limited to, investigation and removal is how we can build a movement to dismantle it. So there's child protective services, jails and detention centers, childcare through vouchers and the daycare system, residential facilities, foster care, preventive services, drug treatment. Refusal is a weapon of the weak, but it's a powerful tool for the asymmetric warfare those of us wage in pursuit of dismantling the child welfare or family regulation system. Asymmetric warfare is not hyperbole. The 2021 budget of the New York City Administration of Children's Services is $2.69 billion. The Federal Administration of Children and Families budget for 2022 is $83 billion. The budget for the intellectual architects of child welfare policy, Annie E. Casey Foundation, is reported to be over $2.9 billion for 2019. What does our site have? Heart, Squad, and Refusal. Particularly in the tech and data policy space where I spend most of my days, people clamor for me to begin with anecdotes of Black children subjected to violence. They say, what's that story about the Black kid who was on Zoom with a toy gun and the white teacher who called cops? Start with that one, and then explain how predictive analytics or automated decision systems, otherwise known as ADS, are well explored in the criminal justice system as reinforcing and amplifying bias. From there, you can make the case that the same garbage in, garbage out dynamics where historical inequities baked into the data sets used by child welfare systems produce the same racial disproportionality we see in predictive policing. And I refuse. I refuse for two reasons. I refuse this desire expressed as a demand for images of Black suffering to prove that we are truly harmed. Like Zoe Sasmudzi so eloquently articulated in White Witness and the Contemporary Lynching, the belief that passive viewership can translate into structural justice is an idea as misguided as it is old. Like Mimi Anua also articulates in When Proof Is Not Enough, this producing of evidence of harm never does the work of ending harm. Second, I'm unconvinced that we are also uninformed about the harms of the family regulation system. As abolitionist and parent advocate Joyce McMillan states, if foster care improved the lives of children, Black people wouldn't be able to get in. I refuse to entertain the pseudo-nuanced conversation about the complexity of child neglect when the very allegations levied against Black families to justify their separation are the plot for a multi-million-dollar comedy franchise. This family comedy without a family grossed nearly $500 million in the same decade that systematically targeted Black communities for incarceration, separation, and poverty. But I'm supposed to recite some elaborate analysis about how the system works? I refuse. I refuse because we can all acknowledge that the mythology of Black deviants, wildland, wolf packs, and super predators was produced in service of distraction. Distraction from whiteness, distraction from race as a technology that sorts, classifies, and deploys us into geographies of safety and unsafety, a technology that doesn't just harm some populations, but a technology that also produces benefits for others. And I just want to highlight that Home Alone 3, the installment, came out 1 month after the passage of the Adoption Safe Families Act, which produced a generation of legal orphans through expediting the termination of parental rights for kids who were in care. And shout out to Movement for Family Power and Joyce McMillan and other grassroots activists and organizers that have initiated a Repeal ASFA campaign. I refuse to engage in a conversation about how to better help the at-risk. Rather, I demand we analyze who categories of deviance benefit. I also insist we examine the particularities of computation, classification, and prediction as a tool of carceral expansion. As Dorothy Roberts poignantly highlights in Digitizing the Carceral State, a review of Virginia Eubank's book, Automating Inequality, prediction has always been central to the carceral state. This is also consistent with the work of Simone Brown, who in Dark Matters traces the genealogy of surveillance to the low-tech tools of the transatlantic slave trade, i.e. branding, ledgers recording the perceived phenotypes of enslaved peoples at point of sale, including columns to denote their worthiness, aka the anticipated value of their labor as a function of their potential to make trouble, lantern laws, and moving closer to what we conceive of as our present, CCTV. Predictive analytics are not just additive to harm. Algorithms in their mathematical connotation are an ideal tactic for the state in that they obscure power relations and intimidate those who think they have no basis, or by extension, right to analyze and demand accountability from algorithmic systems. Also, the Rawlsian legal scholars who write about algorithmic harm often focus on notions of data privacy, leaving many on the front lines of policing systems to feel, how much can I care about them taking my data when the caseworker at the door wants to snatch up my kid? And as an entry point to answering that question, I want to point us to some of ACS's own data. Their multicolored slides, AKA monthly snapshots, might be a little bit overwhelming. But here we can see that legitimately the New York City ACS has decreased its quotas from removal. The foster care census is down to slightly less than 8,000 since its peak in 1996 of almost 50,000. However, enrollment into what's called preventive services has increased as almost an exact function of the decrease in separations. And so I think that we need to examine predictive analytics in relationship to the expansion of prevention services. An activist cry in response to prevention services that we need support, not surveillance. But what I try to outline in my paper is what exactly does surveillance mean in the context of New York City child welfare system? And how and why does this automated prediction dovetail with the Family First Prevention Act? I argue that predictive analytics is not just coding over the cracks of a dysfunctional child welfare system, rather that predicting who needs prevention is central to the massive expansion and rebanding of the family regulation system. And here, I just want to highlight some of the work from Stop LAPD, spying and free radicals. This first image just shows the ecosystem that produces this kind of carceral system. In this case, they were looking at PredPol, which is a geographic-based predictive policing system. And so we often identify some kind of uniform officer, like from the LAPD, as kind of the central character. But in reality, there's a whole ecology of public and private partnered interests that produce this. And I think that this is like a really great way of translating to people how things operate on a community, operational, institutional, ideological level, but even more so to the question of why should I care about them taking my data when they're snatching my kid? It might not be immediately apparent what you're looking at, but they were kind of pursuing and questioning this hypothesis of garbage in, garbage out, meaning that if you have if you're relying on policing historical data sets where Black people, for example, were already over arrested, is the PredPol or the predictive policing system just going to send you back to those same areas identified as high risk because of the absence of white middle class data and the increase of Black and then also low income, et cetera, data? And what they found was that rather than the majority of hotspots that PredPol identified being within Skid Row, it was on the border. And it was creating a new form of enclosure. And why this is very important is because it's not just increasing arrest of certain categories of people, it's basically building up a wall and locking people into Skid Row. So what's happening is not that people are being criminalized for being in there, but they're at risk of arrest and detainment and all types of other kinds of criminal processing if they leave the boundaries that are being given to them. And now this is just a digital wall that is functioning in ways that are hidden to us through an algorithm. But if you physically built a brick and mortar wall around Skid Row, people would riot. And I think that Free Radical and Stop LAPD's research and in this image kind of highlights the severity and the concreteness of the impact of automated decision systems or predictive analytics. The threat is not that algorithmic system will inaccurately predict the outcomes of Black families. To be clear, of course it will. But the more fundamental violence is the process of classifying the dynamic indeterminacy of Black life and Black community. An oft-repeated statement by child welfare policymakers about deploying ADS is that it will remove bias from decision-making. But it's well explored that these are socio-technical systems or otherwise made by human beings who build their view of the world and assumptions about society into the system. ADS does not remove human decision-making. It shifts who makes the decisions away from the frontline caseworkers and middle administrative staff to the upper echelons of administration and the private companies they contract out to for delivery of the typically cloud-based or data center-based software. The algorithm doesn't just make bad or false decisions, it produces new modes of surveillance and social control like we see through the algorithmic ecology. What we're confronting right now is serious, but refusing to be distracted into conversations about the worthiness of Black families, of people with substance use disorders, of the disabled and poor will provide us with more space to develop sophisticated strategies of resistance. The light at the end of the tunnel is an oncoming train. We can spend our time figuring out how to derail it or be ran over as we debate whether it's really revolutionary now. On that note, I'd like to share with you 2 slides that I made on the Fobolition Starter Pack. And so this is the first one. I would like to highlight nonviolent communication, Pride Parade with Northrop Grumman, who develops weapons. Rest in peace to Devontae Hart, depicted here during the Ferguson protests, hugging a white police officer and later ran off of a cliff in a car with his 5 other siblings by his adoptive white vegetarian parents who were starving them. And in the center is a man rushing, in this case to the bus. But I do notice that in this state-sanctioned abolitionist movements where various think tanks and subsidiaries of the child welfare administration are so excited to talk about abolition that they rush real fast from the conversation of abolition to the one of reimagining. And I just really want to highlight and demand that we are not so quick to reimagine with those who have incarcerated us, and for not to rush to dismantle before we actually understand the full depths, expanse, and the machinations of the system which we seek to dismantle. Because what I want for all of us is to get out. And with that, I will just leave you to look at this bingo.
Wow, I want to thank Khadija for sharing that presentation with us. And now we'll turn it over to Tara Coles, who will present work joint with her colleagues at the Center for Family Representation, Hope Newton, Jennifer Feinberg, and Charlotte Bauman. Tara?
Hi, everyone. Thank you so much for that, Kelly. And it is just such an honor to be on this panel with all of these amazing people. And I want to thank, on behalf of Jen and Charlotte and Hope, everyone that put the symposium together and gave us this opportunity and providing this opportunity for everyone to learn more about this really important issue. So when we sat down to write our article, The Surveillance Tentacles of the Child Welfare System, we started out by discussing what we knew to be true about the family regulation system. And based on our work at the Center for Family Representation, our personal experiences, the policy work that we do that's guided by impacted parents in the system, and who then chose to turn around to fight to abolish the system that had been working to destroy their families. And it was very clear to us, as Professor Roberts said last night, that we can't tinker with a system designed at its roots to police poor, Black, Indigenous, immigrant, and other marginalized families as a way of maintaining a racist capitalist system. And so there's a lot to say, right, about a system rooted in white supremacy that works to separate and destroy Black and Brown and Native families by working with other systems, many with similar white supremacist roots. And that's the piece, how these systems work together, that we chose to focus on in our article. So these families are facing a reality that the very institutions and professionals that are meant to provide necessary services to their communities, medical providers, social service agencies, the police, and schools, in reality act as tentacles of surveillance, often entrapping families in the family regulation system. And there's no question, right, that this is the most glaring modern day attempt to destroy the Black family. Mandated reporters, people legally required to call in suspected cases of maltreatment, help the family regulation system to identify families through a cross system of surveillance made up of systems like law enforcement, social services, shelters, and public schools, places that are entrenched in low-income communities of color by design. They feed families into the family regulation system, and once entangled, usually make it more difficult to escape. Low resource families can become entangled in the family regulation system with support or essential services from surveillance tentacles of mandated reporters. Medical personnel, for example, are the source of about 10% of national child maltreatment reports. Mental health professionals make up about 6% of reports, and other social services personnel constitute a little under 11%. The family regulation system also relies heavily on reports from school staff, as they often have the most exposure to children outside of their families, supposedly making them uniquely situated to expose possible neglect. But recent federal data shows that about 90% of child maltreatment reports called in by teachers were not substantiated, which really makes you think about the hysteria and the fear mongering that various so-called children's advocates and politicians and family regulation workers attempted, and sometimes in some ways were very successful, in sowing at the beginning of the pandemic, when it became harder to have white eyes on Black children. It was a harmful and dangerous narrative, but also the perfect example of how society seeks to regulate and control Black families and how it reacts when it can't. And just as the family regulation system depends on schools as surveillance agents, schools depend on surveillance from law enforcement and the family regulation system to surveil and control students and parents. Does anyone remember the story out of Pennsylvania where a school district threatened to call CPS on families with outstanding lunch debt? The cross-system surveillance and partnership between schools and law enforcement and the family regulation system plays a significant role in traumatizing Black and Brown students, parents, and families living in marginalized communities. And this trauma can negatively impact educational outcomes for children, along with their employment stability, physical health, and criminal justice involvement later in life. Law enforcement and family regulation, of course, are two sides of the same racially oppressive coin and work hand in hand to perpetrate surveillance and control over Black and Brown communities. In 2015, the police were the source of 1/5 of all family regulation investigations. And this number is significant given what we know about how Black and Brown people are disproportionately targeted by the police. Targeting by the police feeds the family regulation system through increased surveillance of Black and Brown communities. Black people are more likely to be stopped by police, detained pre-trial, charged with more serious crimes, and sentenced more harshly than white people. And a criminal judge's choice to incarcerate a single parent is effectively a choice to place their child in foster care. Many lose their housing and employment while they wait for their criminal court case to proceed, making reunification even harder. And the family regulation system does very little to support parents who are incarcerated. So just as targeted policing leads to the disproportionate representation of Black and Brown bodies in criminal courts and prisons, the over-surveillance perpetrated by the family regulation system leads to a disproportionate number of Black and Brown children living under the supervision of the family regulation system, whether through a child maltreatment investigation, voluntary or court-ordered services, or in the worst case scenario, the placement of a child in foster care. Investigations and services demanded by the family regulation system can be highly disruptive to families without providing the material support that could ameliorate the poverty-related concern. And it is almost always a poverty-related concern that has led a family to be involved in the family regulation system. The issues that initially brought them into contact in the first place. This is a system that, as we mentioned in the piece, employs attorneys to prosecute parents. And in some jurisdictions like New York City, and implement policies like withholding favorable settlement offers based on a parent's fertility, a tactic with clear white supremacist roots. And we see a lot of other tactics used by the family regulation system and the people they employ in contract with that mirror or parallel the same racist methods of regulating Black and Brown and Native families for years. And so it is imperative that interventions designed to keep children out of foster care reflect the indisputable relationship between poverty and allegations of child maltreatment. Despite numerous studies demonstrating that child maltreatment rates diminish when families receive increased cash assistance and access to safe, affordable housing, the family regulation system does not focus on reducing poverty. We continue to pay other people to take care of Black and Brown children instead of providing direct cash assistance to the family. Initiatives such as the Healing-Centered Schools, which I'm hoping my colleague Hope Newton will have an opportunity to talk more about today, is just one example of an effort that's going on right now that parents and community members are working towards to really help address the needs of the community, as opposed to turning to the family regulation system. So I will leave it there. But again, thank you so much for this opportunity. And I really am looking forward to continuing to learn and hearing questions and talking more. So thanks.
Thank you so much, Tara. We'll now hear from Victoria Copeland from the Department of Social Welfare at UCLA. Victoria.
Hi, everyone. Thank you, Kelly, and thank you, everyone, for being here. Again, I'm Victoria. I'm a PhD student at UCLA in social welfare. I'm going to keep it really short and sweet so we can get to some of the discussion topics, as well as the Q&A. But I'm just going to talk about my article, which is called "It's the Only System We've Got: Exploring Emergency Response Decision-Making in Child Welfare." And I actually did want to highlight really quickly something that Khadija brought up when discussing socio-technical systems. And she really calls us to think about the ways that decisions are being made and how it's diffused into different technologies. And so because of this, I find that exploring decision-making on the front lines from the caseworker perception or point of view has been critically important for my understanding of this. So this current paper that will be in the journal is a grounded theory study that I did with 18 caseworkers across 4 counties. And it was really centralized on learning more about how caseworkers on the front lines, so these are investigative social workers, the first ones to go out, how they make decisions to remove children from their homes. And what I found across interviews was, one, that there was a prevalent and consistent use of surveillance throughout the decision-making process, and 2, that there was a bolstering of monitoring and collaboration through multi-institutional partnerships. So really there was an increase of use of multiple systems throughout the child welfare sort of network. In terms of use of surveillance across interviews, this came in the form of data use and information sharing, as well as the physical monitoring of families. So that looked like caseworkers showing up to folks' homes, showing up to schools and other sites where families or children were at. And I found that this was interesting because although surveillance was expressed as a critical tool in the decision-making process, use of surveillance was also a point of immense tension and reflection for caseworkers. And it really impacted the ways in which they interacted with families and other agencies. And this is something that builds, of course, off of Dorothy Roberts' previous work, which looked at caseworkers as investigators and helpers, which explains the ways in which some caseworkers use coercion and threats during these intrusive investigations, while also being simultaneously held for providing supportive services to families. And so they're really placed in a paradoxical role that really shows, I think, through the paper. And this was experienced through the study in the caseworkers' use of surveillance, because they often felt intrusive, yet felt that their work was required to quote unquote protect children. So under the theme of surveillance, I discussed how the department uses surveillance when working with uncooperative parents. So this really looked at how the department reacts to parents who resist department presence or intrusion for any reason. And then I also discussed how caseworkers use preventative surveillance when dealing with ambiguity. So in many cases, due to just the discretionary nature of the job, there are a lot of gray areas in this decision-making process on the front lines. And then I found that in these times of complexities, caseworkers relied on surveillance and surveillance through multiple systems to help them make a decision when there wasn't enough information that they said they needed. Under the other theme, which is multi-institutional partnerships in decision-making, again, I think through the ways caseworkers work was directly entangled with various systems like hospitals, police departments, and courts. These working partnerships occurred both in person and again through data and technology. This was diffused through forms of mandatory reporting, collaborative trainings, partnered investigations, and also special access privileges, which I thought was something that's really not discussed much. So when I talk about special access privileges, I'm thinking through how caseworkers or frontline caseworkers can talk to children without parent consent in schools. I think through how we have access to certain forms of information through hospitals when parents come in and they are suspected of drug use, things like that. And this too was a point of tension for caseworkers, which can be seen in various quotes I included. For one example, caseworkers shared that, quote, "When we say voluntary services, we say it in a way where it's not voluntary, but they didn't feel safe leaving the kid in the home. This is all noted in the system. If you decline the services, then we will take measures to ensure that we keep the minor safe. So basically read between the lines. If you don't get this, if you don't accept to have these services, we may potentially write up a warrant to take your children." And that was a quote from a caseworker that really, I think, highlighted the ways that the courts are involved, how warrants are involved, and how voluntary services are involved, and sort of this tension that caseworkers are often faced with in their paradoxical roles. There are several points like this in the paper. So generally in this subsection of multi-institution or multi-system partnerships, I discuss, again, the courts, warrants, voluntary services, various law enforcement partnerships. So this looks like collaborative trainings for social workers by police, It talks about shared databases with police and hospitals and schools. And Dorothy Roberts, again, refers to this as a multi-institutional apparatus of surveillance, social control, and punitive regulation. This is, again, from the Digitizing the Carceral State paper that Khadija cited, which is a great paper. And this is also something I am still grappling with today. Overall, the study has led me to consider the use of data and information sharing in child welfare, and also allows me to critically engage with what reforms are being proposed and how they might foundationally fail to address structural issues within child welfare. Some research believe that increasing data and surveillance within the department generally will move child welfare towards a 21st century transformation. And this is said to be better aimed at prevention, which is, again, something that Khadija really highlights in her talk earlier. And further, some research believe that increasing the department's collaborative nature will assist in this efficiency in preventing child maltreatment. But on the other end, there are researchers and families and organizers on the ground that have suggested and shown that surveillance harms communities that already have been historically impacted by various systems. And this includes Black families, immigrant families, and Indigenous families as well. And this is something that I am continuing to work on with my work through not only the academy, but on the ground with organizers in Los Angeles. So I just wanted to shout out my comrades and partners in theory and research. So Downtown Women's Action Coalition in Skid Row, as well as Stop LAPD Spying, whose work you saw earlier in Khadijah's presentation. And thank you for allowing me to share some of that work.
Great. Thank you, Victoria. And I think next we'll have Tarq Ismail from the CUNY School of Law, who I know will pick up on some of the themes that Victoria just outlined. Tarq?
Thanks, Kelly, and thanks to the organizers for pulling this wonderful event together. The symposium has been really wonderful thus far. It's really a joy and a privilege to be presenting alongside my co-panelists. I want to apologize in advance. My Wi-Fi occasionally decides to cut out, so if it does, I'll join back as soon as I can. The genesis of this paper, Consent of the Compelled Child Protective Agents as Law Enforcement Officers, comes from my work in two fora. As a family defense attorney representing parents in neglect and abuse proceedings in Brooklyn Family Court, and as an attorney at the CLEAR Project at CUNY Law School, working with communities affected by so-called national security policy. The overlap may not be obvious, so I'm going to take just a minute to explain my perspective. When the state is claiming to protect a particularly sensitive interest, be it the well-being of a child, for example, or the security of the homeland, agents of the state are deployed with the near full imprimatur of the polity: protect children at all costs, stop terrorism, come what may. Based on this blank check drawn against the trust of the citizenry, the state is authorized to operate in a subjudicial way. State agents surveil communities and gather information on them and use the executive's immense coercive power to safeguard the interests they have in mind by the precise means they have in mind, usually along policy lines that reflect baked-in racism. The work that state agents are doing is subjudicial in that their coercive power is being used outside the bounds of a juridical process. There's no court involvement which would theoretically be designed to check or to restrain that power. Think, for example, of an FBI agent knocking on someone's door just to talk, or a child protective agent knocking on a family's door to follow up on a call to the child maltreatment hotline. A case is escalated from the subjudicial to the judicial if and when agents determine that the coercive power at their disposal is insufficient to achieve their goals. An FBI agent brings a case to an AUSA, CPS brings it to family court. What struck me in the comparison between these two, though, was that despite the similarities in their ambit, FBI agents, and really all criminal police, are law enforcement officers when we emerge from the world of the subjudicial into the judicial. CPS agents simply aren't. For cops, evidence is excluded from a trial if it was obtained through unconstitutional means. There are clear mechanisms set out to ensure that the consent obtained by the agent was freely given: warrants, Miranda warnings, protections against coercion, troubled and ineffective as those protections may be. Those protections, nonetheless, are nowhere to be found in the world of CPS agents because the law doesn't treat them as law enforcement officers, even though they have the vast coercive powers to enforce the law. So with this project, I tried to explore how various layers of family regulation policy, federal statutes, regulations, and policy guidelines, which set out the terms by which federal dollars flow into state coffers, and then state statutes, regulations, and policy guidelines and handbooks putting those policies into motion actually require CPS agents to act as law enforcement officers while simultaneously assuming and even also requiring that the subjects of those investigations will be entirely compliant with their coercion. I examine why legislatures have turned a blind eye to this reality and then look at how and why federal and state courts have accommodated such a massive sidestep. Ultimately, I conclude that this web of statutes, regulations, case law, and policy at both state and federal level, the law, as it were, establishes a structure which is entirely reliant on parental consent for invasion of their fundamental rights in order for CPS workers to conduct their investigations. I suggest that at various levels, at the level of public consciousness, at the level of legal practice, and in an effort to imagine a world that provides resources to thrive instead of a web of surveillance designed to regulate Black, Brown, and Indigenous families, we owe it to ourselves and, more importantly, to the families affected by the system to treat CPS agents as they should be treated, as cops. Let me try and illustrate this point with an example. A call comes into the New York statewide central register. A teacher says he saw something concerning in the background of a Zoom window, maybe during math class. The teacher noticed the house was a mess, or that an adult was smoking a joint in the house. The teacher, because he believes the law requires him to do so under penalty of arrest, no less, calls in the case. Just to be on the safe side, an officer in Albany screens in the call and assigns it to the local Child Protective Service Office, ACS, for investigation. An ACS agent heads out to the home of the child and introduces herself. She says she needs to take a look around and the parent lets her in. As I write in the piece, the ACS agent achieves entry into the home on multiple grounds. A parent likely believes she has a choice to refuse, and the ACS agent certainly doesn't disabuse her of that notion. She likely believes it's the fastest way to get rid of the problem, and she's likely aware of the immense power that the ACS agent has because she's statistically more likely to have neighbors who had interactions with ACS, including interactions in which her neighbors' kids were removed and put with strangers. So she lets the agent in. The ACS agent speaks directly with parents and children old enough to talk about the intimate details of their lives. She opens the family's fridge and cabinets, counting beds and cribs and clothes, examining window guards and safety coverings on electrical outlets, and taking notes on the home's tidiness and upkeep. She may examine children's bodies or ask adults in the home to give a urine sample for a drug test. She will no doubt speak to the teacher and may ask that a HIPAA release is signed to speak with a pediatrician. ACS agents have the power to remove children without even going to court first. Ultimately, the agent will reduce her investigation, interactions, and observations to writing, including, as Victoria highlighted, the demeanor and degree of the compliance of the parents, and ultimately decide on the underlying allegation. While most cases are ultimately deemed unfounded, those cases which are indicated stay on a parent's record for years and adversely impact their ability to work with, foster, or adopt kids in the future. And that means ACS agents may continue to come back to their home to conduct ongoing rolling investigation. If the ACS agent determines that the coercive power at her disposal is insufficient to bring the family in line, a case is filed in family court seeking court-ordered supervision of the backbone for her case are okay. All right. And the backbone for her case are the records of the investigation conducted at the outset. Child welfare cases can last years, and their implications are no less dire than their criminal or immigration counterparts. The visits continue for the life of the case, as so many of you know, which often result in a battery of mandated services for the parents, all of which serve as a condition for the children remaining in their care. And as many of you know, and as we've discussed already at length, in some cases, on the basis of these investigations, parents suffer what many of us have called the civil death penalty, the termination of their parental rights. So the ACS investigation I'm describing isn't a consequence of the individual agent's whims or her supervisor's discretion. It's not even just a policy in a handbook. The ACS agent investigation I'm describing is actually required by state statute. Focusing just on the search of the family's home for today's purposes, New York, for example, requires that for every call that comes into the SCR, each call is required to get an appropriate investigation by the local CPS agency, including, quote, an evaluation of the environment of the child named in the report and any other children in the same home. By analysis of state statutes with the invaluable help of my research assistants, Ian Sinclair and Emily Pickens, that analysis shows that at least 35 statutes countrywide authorize a home search as part of a CPS investigation, with at least 27 of those actually mandating the search of the home. And you see similar patterns of mandated law enforcement conduct for interrogation of parents and interrogation of children. Meanwhile, only 15 states or territories even contemplate some sort of CPS warrant statute for a home search, with only 6 of those 15 holding CPS to a probable cause standard if they want to enter a home. As with other policing efforts, CPS funds and resources, seeks funds and resources to expand their policing capacity. In New York, CPS train directly with the NYPD. They take the quote unquote criminal investigators course at the NYPD Training Academy and have set up a training facility called the Fun House, where ACS sets up a mock multi-room apartment with hired actors for ACS officers to train on how to conduct home searches. In Texas, the Department of Family and Protective Services hires special investigators. These are retired police brought in for their experience with primary duties involving forensic and investigative methods to train CPS agents. This conversion of state statutes and practice isn't a coincidence either. CAPTA, the Child Abuse Prevention and Treatment Act, which lays out the framework for state CPS investigations, requires that states implement a mandated reporter system, and then requires that CPS agencies conduct prompt investigations of every screened-in report that comes into their system. As mandated by CAPTA, the Children's Bureau of the Department of Health and Human Services sets forth in-depth guidance on what those investigations are supposed to look like. And according to the most recent guide from 2019, such investigations are to include, among other things, interviews with the child identified in the report, their siblings and any other children living in the home, interviews of all adults living in the home, non-resident parents and the alleged maltreating parent, observations of the interaction among the child, siblings, and parents, observation of the home, neighborhood, and general climate of the family's environment, and compiling information from other sources who may have information about the alleged maltreatment, family dynamics, or the risk and safety of the children. So after having looked at all of this stuff, I applied the duck test, right? Or at least sought to see if federal courts applied the duck test. If CPS trains like law enforcement, if they investigate like law enforcement, if they have the statutory authority to infringe your fundamental rights like law enforcement, courts must treat them like law enforcement, right? No, not so much. It turns out that the federal courts are actually split on the question of how and to what extent the Fourth Amendment even applies to CPS searches. 5 circuits have held that the Constitution requires a warrant supported by probable cause to enter a home, and 4 others disagree on whether that's even the case, with some still applying the special needs exception to the Fourth Amendment. What's interested me here, though, is the way in which the courts have come to this conclusion. They've concluded that probable cause was required for CPS to enter a home, not because of the coercive power of CPS agents or their fundamental ability to disrupt fundamental constitutional rights, but because CPS work was quote unquote intimately intertwined with criminal law enforcement. So I guess that makes the police the duck and CPS, I don't know, like the swan or something in the eyes of the federal court. I've yet to dig too deep into the state court's positions on this matter. And I mean, honestly, that's probably another project entirely. But ultimately, I conclude here that because of the reality that I've described, parents are set up to fail if they don't consent CPS's investigations unless we take some really concerted and organized measures. And so those include know your rights presentations, but know your rights presentations with teeth. Meaning, if we're going to tell people what their rights are, then we need to back them up and provide lawyers who will say, my client said no because they have a right to do so. And we need defense organizations who are willing to stand up for that position. And I come to that conclusion for a variety of reasons, right? We need to be able to defend communities and their interests today, but we also need to set the stage for abolishing police where it's actually easier potentially to abolish police. We need support without strings, right? And so there are a number of strategies that I point to for what the legal system can incorporate to make this happen, and we can get to those in a bit, and I'm sorry for going on a bit, but thank you for your attention.
Great. Thank you so much to Tarq and to all of our presenters today. This was really fantastic to hear from all of you. I heard a number of common themes, right? So from this idea of surveillance that's disguised as support or, quote unquote prevention, this idea of interinstitutional surveillance and data sharing, overlaps with the criminal justice system, families being stripped of any meaningful rights to refuse or to protect themselves from surveillance. And so all of this, and I will encourage all of you who are here today to read the papers that come out in the journal when it's published. All of this is a really powerful indictment of how things operate today. And I want to pose just a few questions as we kind of look ahead to think about building a better society. And again, feel free to direct specific questions to me in the chat, and I will pose those to our panelists as well at the end. So first, a number of you spoke about how these interinstitutional collaborations, especially through things like data sharing and mandated reporting, really expand this net of surveillance. And so I wanted to ask, what can or what should entities like schools and mental health providers do differently to support families? So Hope, maybe, do you want to kick us off?
You know that Hope is going to take that question, okay? My name is Hope Newton, and I am on the CFR policy team, but I also wear a number of hats. I talk about healing-centered schools as an abolitionist model to address these issues where there's an intersection between education, criminal justice, as well as child welfare, because schools are also places where families and children are re-traumatized. There are places where trauma takes place. When you have a school safety officer, when a school safety officer is listed as that person who comes to de-escalate any type of altercation or any type of conflict between children, when they are trained to arrest, detain, and write summons, children don't feel safe. Parents don't feel safe because parents are also in marginalized communities also targeted. When we talk about child welfare, we talk about neglect, we talk about poor people who are poor, who are impacted. So parents don't feel safe if their children are in schools with school safety officers, some, and they don't also feel safe because interacting with schools that also call in cases. Throughout COVID, we saw that there were a lot of cases, case numbers were down. There were calls about, we aren't hearing things, we don't see what's going on. And when we're talking about that, we're talking about what those connections are for people to determine children are not safe with their families. But I'm here to say that what we've seen is that because the systems were shut down and there weren't eyes on families, there was robust advocacy with parents across the board because parents had to come together. And one of those organizations I'm talking about is Healing Centered Schools, is a model that focuses on not only the safety of children, the safety of parents, the safety of teachers and administrators at school who experience vicarious trauma. It is a paradigm shift in thinking about how we move forward from what happened in COVID that highlighted all of the disparities. And I know I'm saying a lot, but I want to try to keep it focused on the things that are used within the Healing Centered Schools model. You've heard about it, social emotional learning. We're talking about culturally responsive sustaining education. We're talking about restorative justice practices, but we're also talking about centering the safety of family, parents, students, and administration coming together to identify what the challenges are, what the barriers to learning are. And that's foundational because parents come to schools. School is a place where their children are expected to learn, and that's the expectation that happens. That's the expectation that parents have. So Healing Centered Schools is one of those models, but I also want to talk about how parents came together. Everyone here or may or may not know about the work of RISE. You know, RISE Magazine talks about the experiences of parents. We also have PLAN, which is parents coming together to talk about legislation. We also have the work that many people don't know about, parents supporting parents. There's a large segment of people, of families that are not being reached because they don't have access to the internet. There's a woman named Tanisha Grant with Parents Supporting Parents who raised money to buy laptops for children in Harlem schools that did not have that. That's what we talk about when we're talking about family, parents, and communities coming together to address the needs in community. So when you start to have a paradigm shift that it's not just we, those who know education, we who've studied it and know what's best for you, when you involve the parents and the community and you allow children's voices to speak about what their needs are, where they feel safe, then we can move towards transformation, education, and creating something that is not just reimagined, but there's a concrete example in the Healing Centered Schools as a way to move forward. It's a solution. What else we got going on? We might as well go for it.
Absolutely. Thank you, Hope. Other thoughts, and I'll bring in some kind of questions that build on this as well from the audience, specifically with respect to mandated reporting. We have a question about sort of how these providers can provide support without, like, given the strings of mandated reporting, right? Any social service organization that receives government money is required to report, although many know better than to report families for anything less than imminent risk. That's a question from Sarah Childs.
I'll jump in. So I think that, you know, what we've all been talking about is that there's just simply nowhere for parents to go where there aren't mandated reporters. And we're talking in a space where ACS, well, in New York, the Administration for Children's Services is talking about even expanding that reach. We're dealing with Family First, which, you know, we can also address. But currently, you know, the Administration for Children's Services is expanding what they call their family enrichment centers, which, you know, they're basically deceiving parents by not attaching their name to it. But these are community-based centers that are supposed to provide support. But in reality, they're just part of ACS. And parents who go there are still being, you know, subject to mandated reporters. They're not seeing someone and being treated by someone who they can trust. And parents are not going to want to seek services there because there will be, you know, they will know that eventually these are mandated reporters. These are affiliated with ACS and foster care agencies. And they're not providing the service. In the end of the day, the services are not necessarily getting to those parents. And I think in terms of mandated reporters, we have to think about if the purpose is protecting children and getting children the services and resources they need, then perhaps the emphasis should be on teaching mandated reporters how to facilitate getting those resources and services to parents instead of simply picking up the phone and calling the prosecutor, the family policing agency, to step in and investigate. The investigation is not providing, it's not solving the problem. They need to be directly solving. Mandated reporters should be, instead of being mandated reporters, they should be solving the problem and providing resources. And so, you know, if a school sees that a child is hungry, don't call ACS. That school should be seeing if they can solve that problem absent the family regulation system, which they can. It's very easy to find community-based services and programs that can provide the necessary services for parents. The vast majority, as we touched upon, of calls are neglect-based calls based on poverty. The vast majority of reports are based on poverty. If this is a poverty issue, let's address the issue. We shouldn't be investigating the parent because they live in poverty.
I would love to hop in. So I think just before I get a little bit more abstract, just more concretely, I would love to see people support legislation around like repealing mandatory reporting, just because that is already happening and there is not enough support for that. Movement for Family Power is doing a lot of great work around that. So a lot of the times I think I see this question come up a lot, but there are already things moving in community. So if you plug into community organizers, community organizations, families who have been impacted by the system, if you just plug in and begin to listen to some of the calls and some of the policy that's been moving already, I think you can learn a lot from some of that. So I would say I would love to see more people and organizations support that work that's already happening on the ground. And yeah, I think that's just something I wanted to say. But I think, you know, just from hearing some of the responses and even just in my own work, thinking through this, I really, in social work especially, we are really clinging to some of these like Band-Aid, I think, fixes to a lot of these things, and that includes cultural competence training, implicit bias training, that I think a lot of people say is necessary, and I can understand from a reformist point of view why that seems like it's a necessary step into improving the system. But if we're speaking in terms of abolishing the child welfare system, I don't believe that these cultural competency trainings or implicit bias trainings in mandatory reporting is actually getting to the issues that are really undergirding the harms of the child welfare system, right? I don't think we're, speaking for myself as an abolitionist, I am not attempting to make mandatory reporting better or kinder or nicer. I'm also not trying to make family removal more culturally competent. I don't think any of that makes sense. I actually think it's contradictory to the work that that I'm trying to make happen in terms of abolition. And so I think what's really important for me is for us to think about how speaking about child safety and child protection actually fuels a lot of these different more reformist fixes and how it fuels the need for surveillance. So if we're talking, continuously talking about protecting children and prioritizing the protection of families, it sort of, for me, centralizes the system of ownership or property or something that's an object. And it also reinforces, it reinforces the need for surveillance. If you're trying to protect something, you have to watch it. You have to be able to monitor it. You have to make sure that things are happening a certain way, that they're meeting the norms or the needs of the state, of the government, basically the statutes of the child welfare system. And so I think that problematizing the use of child protection is really helpful for us to move forward in abolition. And I think Dorothy has said this a lot, especially in Shattered Bonds, but continues to say that this sort of pendulum shifts between family preservation and child protection. So if we're continuing to use this sort of ideological attachment in our future sort of vision for child welfare or for thinking through child maltreatment, then I think that we are sort of moving in the wrong direction. And so that's just something that I wanted to bring up for people to think about more deeply. And that's something that I'm thinking about as well.
Thanks, Victoria. And that actually, part of what you said actually responds to another question from Heather in the audience about how can we undo mandated reporting laws. So thanks for that. Any of the other panelists want to jump in?
I just want to get back to that whole community piecing because community became really important, and a lot of organizations, governmental organizations, are looking at how do we reach out to community and address these questions that you're talking about. And what I find is that when community has challenges, community steps up to do what they can. There will be some people who fall through the cracks, but they start having conversations with others in systems about mandated reporting and how do you look at what you're doing. We know that mandated reporting, their license is connected to the work that you do. But there are conversations that people are having, community, which seems to be underground to a lot of people who work in systems, about, do you know what happens after you make that call? Like, you've been trained that you're doing your job, but let me tell you what's really happening. And let me bring some people in to let you know that what's happening. And then, because people in some of these roles are so disconnected, from the reality of what happens. I'm not going to say all of them, I'm going to say some of them, because I see what happens in the community. But those things are going on. Those are some grassroots things that are happening in the community. You have parents and students working and identifying challenges in schools and saying, okay, well, we have some students who aren't doing well, and coming to those problems and coming up with projects to help move people forward. But then we're seeing that those students and those parents and those teachers will be re-victimized if the mindset that's based on white supremacy dismantles those programs, because it sends the message that certain lives don't matter, certain students don't matter, the elevation of students who are, maybe failing, excelling doesn't matter. So there's so many different things that we're talking about when we're talking about dealing with this. And it's really a mind shift. We're shifting the way we're thinking and the way we're doing things. And it's going to take a while, but trust and believe, there's boots to the ground that's working on it. It's just that a lot of people may not have access to all of them, because there's a large segment of people who do not have access to internet 24 hours. And we're leaving that group of people out of the conversation because people don't know how to reach them. But there are people in the community that do. So you're going to see a lot of collaborations and people coming together. And I just wanted to name that because I think people don't know how to reach that population, and they're forgotten, and they're part of the solution too.
Absolutely. Thanks, Hope. And actually your comments about this mind shift really get to a set of questions that have come in around like narrative shifts. So Jill Cohen asked, how does ACS react to the institutional legal services providers like the CFR using the term family regulation system? And how do you handle that in day-to-day activities like court appearances, family meetings at the agencies, et cetera? And maybe folks from CFR can also speak a little bit about the kind of systems and narrative change work that you're doing alongside direct legal advocacy. We also have a question from Charnel, sort of related. Charnel wrote, in my context in BC, Canada, our child welfare system is perpetuating an ongoing colonial legacy, but there's a lack of appetite for the mainstream to address major overhaul and abolishing, as the bad apples narrative continues in the framing of child safety. Have any speakers had success in engaging the mainstream public in supporting, abolishing, and doing away with surveillance? Relatedly, a question that any of you may want to speak to as well, from Michael Moore, writes, how do we counter the narrative among non-impacted, primarily white, liberal, middle-class communities that the solution is to foster and adopt more kids? Maybe we can start there with someone from CFR.
So I'll hop in a little bit on how the narrative is received. I think that, one of the things that I want to start with in terms of being a parent defense provider, we're constantly balancing our policy work and what we're advocating for as systemic change with, it's not necessarily balance, but we also need to be representing our clients. And ensuring that we are doing the best that we can for our clients in the courtroom and moving their cases forward as quickly as possible. And so I will point to, like, there was a city council hearing earlier this week where all of the defense providers testified about the family regulation system and called ACS out for it. ACS spoke for, I don't know, 2.5 hours at the city council hearing. The commissioner was there, the deputy commissioners, lauding all of their work during the pandemic. It was specifically about their response to the COVID pandemic. And everything is whitewashed. Everything is, about how well ACS handled everything and how we're working so well with the parent offenders. And then everyone left except for one ACS representative. And, then the parent offenders were able to testify about what really was happening and what was really going on and how the regulation was affecting the parents we serve. And how ACS failed to do what they needed to do during this critical time. And now we're 15 months later with cases having lingered with really nothing, no progress being made. So we are constantly pushing that in the policy sphere. And I would say in court, we are trying to call out the system as racist, point out to judges that these allegations are, the allegations against our clients are racist and poverty driven often. And we're doing what we can on a case-by-case basis, but also while we have to make sure that we are not damaging relationships in a way that will prevent us from representing our clients well in court. So I think that it's a hard balance. I don't think that ACS, at least I have not had the opportunity to have any direct conversations with anyone at ACS. I don't find that the attorneys, the prosecutors in court they're not feeling the shift yet. I think that they are missing the point. And as Tara mentioned earlier, like the way that attorneys are acting in court, they have not grasped the racist system that they are part of. And they are perpetuating that racism through denying, positive settlement offers because it's a young parent who may have other children and they want to be able to control that parent down the road when they have that next child. And so, we're pushing back, but there's certainly a tension, I think, when it comes to our in-court advocacy about how we do that in a way that is client-centered.
I just also would want to add, I think part of like what that tension is that as institutional providers, we're part of the system, right? So like we advocate for parents, we have social workers and parent advocates that work for people who have been accused of neglecting their children. But at the end of the day, we're still, we're part of that same court system. We're still advising our clients around the same laws that in the policy realm, like Jim was saying, we are calling out for being racist. And policies that are having a disproportionate impact on our clients. So it's hard to try to shift the narrative while also doing the in-court work and conference work that we are ethically required to do and that we need to do as attorneys when we're representing parents who a lot of times, their main ask of us is to make it so they walk out of that building with their baby. And that's the number one thing that they want when we meet them on day one. We have to break the news to them that the stranger that they met 2 minutes ago that knows nothing about their family wants to take their baby. And that's our number one obligation when we walk into the courtroom, is to advise them and work with them around that. But we certainly do, I think, even being part of the system, to help shift that narrative and to work on changing the way that the system impacts our clients to the extent that we can until it can be abolished.
I'll weigh in and say, I mean, I'm getting messages from some of my former colleagues at BDS who are kind of giving me their perspectives on this point too. So I want to lift those up as well and say, I mean, you know, if we were to raise this idea, for example, that our client did not let a CPS officer in because they don't have to, that point is laughable as far as most family court judges are concerned, right? To my mind, though, that doesn't mean that we shouldn't make that point until it's no longer laughable. The same is true when it comes to naming ACS, FCLS, as they like to call themselves here, as prosecutors. They are prosecutors. They're prosecuting the state's law, which is designed to affect the fundamental right. I mean, if we want to use constitutional and legal language, right, which is designed to interrupt fundamental rights at issue in court. You know, and in the same way that I made the argument earlier, you know, ACS agents, I call them agents because they are an arm of the state, and they are acting as an arm of the state when they walk into your house, when they investigate, because ultimately they can, you know, do what they want with that information to interrupt your fundamental rights. So to my mind, and this may be like me speaking from having been in practice and then sort of still in practice as a clinical professor, but maybe a bit further away, you know, imagining a different reality. Like, I think it's, you know, we have to be willing to push on the discomfort that comes with saying to a judge, hey, my client is invoking their Fourth Amendment rights here. Hey, you know, client, that is a prosecutor over there. Hey, that person is a cop who walked into your door. Like, naming the things for what they are, as compared to sort of, you know, dancing around that reality. Because it's true that we all have repeat players in court, and we have to sort of be willing and able to get the best results for our clients. But frankly, those repeat players are going to think of our clients what they think, regardless of how hard we push back. And I'm not convinced that like holding back in that respect is doing our clients any favors in the long run. And I'm not suggesting, by the way, that like that's what you all were saying, but I just want to say that like I think that's called for in this instance.
Do I have time, Kelly? Or you can ask the next question as well. That's totally fine.
Go ahead.
Okay. Yeah, I often speak from a social work perspective because that's what I'm trained in. But just generally for people, I think we have to question what mass refusal looks like. This is something that Khadija spoke a lot about when she was talking earlier. And I think a lot of people sort of hesitate, maybe because they're scared, maybe because of a conflict in funding for organizations. Different foundations have certain ties with surveillance, with prevention services, data accumulation, technology, things like that. And I think that we have to consider, what does mass refusal look like? Does that mean that my organization has to find different funding? Does that mean that as a social worker, I might have to find a different job? Does that mean that I'm not going to sit on this board for certain things? Do I create something else besides being in the child welfare system? It really is a consideration of what refusal looks like. And I think that it's very necessary for us to sit in that uncomfortability because that's the only way that we're going to change anything. And I think that we have become so comfortable, not only in this system because it's just existed for so long, but we have become so comfortable in thinking that our positions are required for, again, the protection of children. And I think that we really have to interrogate that within ourselves. I think something else that is important is to read things in a different lens that you have been reading them before. And I think that has been really helpful for me when I started this journey into a more abolitionist praxis, is starting to read into these different policies and legislation that has been passed. So for example, the Family First Act, FFPA, it looks all good and dandy, right? When it comes out, oh, we're shifting our ideologies to family preservation, yada, yada, but it's so exclusionary. And if we're really wanting abolitionist restorative justice practice or transformative justice, it doesn't do that really in any way. It's really structured, especially in California. We have like an evidence-based clearinghouse where there are certain specific services that families are required to choose from, or practitioners are required to choose from, to even be eligible for some of this funding. So you have to really, I think, do the work in terms of reading these bills more closely and thinking about the implications it has largely and individually. And I think that this is somewhere where social welfare or social workers are uniquely positioned to read this in this sort of way, right? From this more macro system way to an individual way. And I think that we have to start using that to be critical about our role and thinking through what mass refusal looks like. And I'm still thinking through this, and I'm thinking through this with all of you today. So these are just some of my thoughts.
Yeah, thanks, Victoria. And I guess maybe building off of that, I'm curious, based on your research, kind of in this context of what you're calling mass refusal, how would you talk about this with some of the caseworkers that you spoke with? We had a question come in from Stephen, interested in the perspective on CPS caseworkers on the front line who are under extraordinary pressure, who will be on the front page of the New York Post if a child dies, who receive very little support and training. And I know that you spoke with frontline workers about the pressures that they feel and the surveillance that they enact in the context of that pressure. And I just wanted to give you an opportunity to speak a little bit more about that too.
Yeah, so this is interesting because I am trained in social work. So I did a program that also went through basically like training to be a child welfare worker, though I was never going to do it and never did do it. I sat in some of those classes as well. And you have to actually, even before that, understand that a lot of universities are pipelines into the child welfare system. So again, what does refusal at the university level, at the academic level, what does that actually look like as well? Because we are also pipelining caseworkers into the system. We're also getting a lot of students who they need that, master students who need that funding to actually complete the program, but then they're, the stipulation is they have to give 2 years into the child welfare system to not have to be responsible for that funding. So we have to really reconsider what do these relationships look like in these different system levels. And I think it's a very complex and deep situation. In terms of speaking with child welfare workers, I think that it was really interesting. Some of the caseworkers, the tension was so intense for them that they had to quit their jobs. So I had caseworkers who literally were like, I'm quitting my job, or I've quit my job because I am unable to rectify this tension. It's too much for me. On the other end, there are caseworkers who I think, because the nature of the work is so stressful and because of this tension, that they've had to normalize it in a way. And so it becomes less of a shock or startle or less uncomfortable for them to do this work. Now, I also wanted to call attention to, I think there's another layer in CPS work that gets unaddressed, and that is social work supervisors. So a lot of times frontline caseworkers, they have to get approval from their supervisors to, one, override the decisions that are made through like structured decision-making tools or risk assessment tools. They have to get approval to override that risk score. They also have to get approval from supervisors for any other sorts of discretionary judgments that they're making. And oftentimes there's this disconnect because social work caseworkers or emergency response caseworkers, their supervisors aren't seeing families every day. And caseworkers on the front lines are. So there's also this tension in like, okay, well, I'm seeing this happen every day, but I don't have the power to say no. A lot of caseworkers said, I don't feel like I have the power to say no to my supervisor. And so if they want to detain, I have to detain. Detain is what they say when they're removing children from the home. So I think that it's a very complex system. And again, this is why it makes reform, I think, one, so hard, and two, it just seems like no reform will work at this point for me, in my own opinion, because there are so many layers of power and just band-aid responses to an issue that is not even being resolved by this system. So I think that although it's very, very important to think about these tensions because it's still happening every day, like people are at work right now dealing with this, I think that it's very important for us to think about it. But I also think that like, when we talk about mass refusal, we're talking about like, what does our work as social workers look like without this system? How do I help families who want my help outside of the system? And I think it's really important that caseworkers, like if you're in the child welfare system right now, that you are thinking through these things and you're thinking through, okay, well, in my work, what would this look like? Because I don't have the answer to that because I'm not doing this work every day. I can only speak from the perspective I'm seeing and hearing from you all. So I think it's really important for you all to think through together, what does mass refusal look like as a caseworker? Like, what does it look like for me to take another job? What does it look like for me to create something outside of the system? And I can't answer that question for you concretely, but I think that different spaces are willing to sort of work through that with you outside of your job. So, sorry.
Yeah, thanks, Victoria. And related, I think, to this question or this idea of kind of building towards the larger scale transformation while also kind of doing the harm reduction work, that has to happen today. We have a question from Nora for Tarq about how the law can be used to de-police what's required of CPS, and asking, is anything incremental possible towards abolishing mandated reporting? Tarq, I don't know if you have thoughts on that.
Yeah, it's an interesting question to think about it from the other way, which is sort of how do we de-police CPS as compared to sort of actually naming them for what they are? I mean, that's a bigger conversation about, taking away the stick that Kelly kind of writes about in her piece when it about sort of the power of coercion that CPS has. CPS acts as police because they can walk around and threaten people that if they don't do X, Y will happen. If they don't have the ability to threaten X and only have the resources to provide Y, then we're in a different world. But that's not something that standing up in a day-to-day courtroom is going to disabuse, or not disabuse, is going to remove from CPS's arsenal. So there are other, I mean, I think in line with what Victoria and Khadija are saying, mass refusal also involves refusal of sort of CPS entering into your home on the front line, closing the front door and saying, no, that's a tactic that will require CPS to re-examine how they do their work. It's a harm reduction tactic because as long as they have X, we're still talking about a world in which abolition is necessary. But at the very least, that's one harm reduction tactic that I think we can get behind. So long as I say, there are people who are able to sort of stand behind it and enforce that choice. I don't think, for what it's worth, that choice being enforced is a cure-all either. Because we know that consent in the criminal justice system is manufactured in so many different ways. But in this case, they don't even have to go through the motions of manufacturing consent. They just take it. And so at the very least here, what you would be doing is putting CPS through the paces of their responsibilities and making it harder for them to surveil.
Yeah, thanks, Tarq. So we have a number of questions coming in around, people are really interested in, how providers like school staff, healthcare workers, others can manage the position that they're put in. And so there's a lot of questions around that I hope that maybe we can get into in the breakout sessions. We just have a few minutes left. This panel has really flown by. And I thought that maybe, to close out, we could kind of do a rapid fire. And I'd love to hear from each of you kind of looking ahead, something that gives you hope with respect to family surveillance going forward. We can do this kind of rapid fire.
I guess I'll start. It's like rapid fire and then no one talks. Yeah, I think slow fire. What makes me happy, or what makes me optimistic is the work that's happening on the ground by families. Again, plug for Joyce, Movement for Family Power, but also in LA, working with Downtown Women's Action Coalition through LA Can, and Skid Row and Stop LAPD Spying Coalition. There's so much work happening. There's so much, I think, passion. And I think that part of this work of people who are in practice or at the higher level is to listen, to stand back and listen. Sometimes you just don't need to talk. Sometimes you just don't need to take space. And I think that part of that work right now is to step back and listen and support. And so I think that community organizing has been giving me a lot of hope right now. So, yeah.
I'm going to, for me, obviously, it's the Healing Centered Schools model that's talking about a paradigm shift and looking at parents coming together, like the parent, Tanisha Grant, with parents supporting parents who came and, you know, really galvanized parents coming together around issues of education and, you know, doing fundraisers to get laptops into children's homes when they were having problems with access. So just parents coming together, helping parents and identifying that, that gives me a lot of hope as we're moving towards a mind shift across the board, because I'm hearing conversations everywhere about changes and what that looks like. So that gives me hope.
Thanks. Tara?
Sorry for interrupting, Hope. I didn't realize you were coming off mute at the same time. But I'm in a similar space as Hope and Victoria. I'm really just inspired and hopeful in the activism and organizing that parents have been doing in this space. And really excited that so many of the providers, I know at least in the city, and I'm hopeful that it will also gain traction at the national level, specifically in connection with repealing ASFA, and that these providers are really trying to allowing themselves to be guided by the people who are impacted and learning from them. I think it's really easy in general to kind of use whatever education experience you might have to try to like take over the space, kind of back towards what Victoria was saying. But this movement of being guided by people who are being most impacted by the system, I think is really important. And I'm hopeful that it's going to continue and lead to the change that we've been hoping for.
Tarq, Jennifer, Charlotte, anything to add?
I'll jump in and say I've been just really, really inspired by the work that Plan and others have done here in New York to propose really concrete, legislation that, and recognizing that it's sort of a rock that needs pushing up the hill and that it may sort of stumble back, but will continue to be pushed up. And beyond that, I think what's so amazing now is, especially with the Movement for Family Power, amplifying and doing so much organizing, like there's now that sort of organizing, also being amplified in communities around the country. And that sort of work is super duper important for addressing the federal floor that is set for so many of these policies, whether it's ASFA or CAPTA, like we've talked about. I mean, having buy-in and organizing happening across the country that folks are dictating their own fates seems really important and inspiring. So to me, that's what it is.
I'm gonna just echo everyone else. I think we're all inspired by just all the activism on the ground. I just this week, I mentioned the city council hearing. Joyce brought, multiple many parents to come testify before city council about their experiences. I think if we want any legislative change, legislators need to hear directly from the parents, directly from youth affected by this system. And it's just amazing to see how many parents are stepping up to advocate and to be on the ground, boots on the ground. It's really great to see, because the institutional providers, all these organizations are not going to be as effective without all the grassroots organizing.
Awesome. Charlotte.
Thank you. I just want to add to piggyback off of what everyone else raised, the parent-led organizing, especially around not only legislative solutions to the family regulation system and the family policing system, but also envisioning new and unsurveilled forms of support for families that can flourish in communities and not be a part of the system and not perpetuate the surveillance and harm done by the system. I think is extremely inspiring, and look forward to seeing where that goes.
Great. Well, thank you all to the panelists, and on behalf of the panelists, I want to thank all of you for coming. We do have some breakout rooms in the sort of break between sessions. I believe that you'll be able to select your breakout room at the bottom of your screen. If you have any difficulty with this, feel free to message anyone with AV in their name, and they can help you get that sorted out. So just thank you all so much for coming, and hopefully we can continue some of the conversations in the breakout rooms and beyond. Thanks, everyone.